Good morning. Today I will discuss about how to argue criminal cases. After filing charge sheet, what shall be the stages to argue the case? Number one stage that if it is summary trial, questioning will be there. So earlier there was no opportunity to object for questioning the accused, but subsequently by judicial president, the accused are permitted to file preliminary objection for questioning the accused. So when a negotiable instrument act were tried as summary trial, that facilities were given. So that time you can argue, not that you are innocent and other things, only on technical ground that the material facts is not sufficient to question the accused, or there was a lack of jurisdiction for the prosecuting authority, or lack of sanction, whatever it may be. For special act prosecution like food adulteration, corporation cases, that act itself says that without a accord means permission of the particular authority, prosecution may not be initiated. That will be there. All these points should be raised, barred by limitation in view of 468 CRPC, where some limitations are there to take cognizance. That we will look into later on. Then a question of framing of a charge if it is warrant case. So first the courts are directed to hear the other side, and if they consider that there is no prima facie material to frame charge, then automatically they will discharge. That was the first sections. Then only if there is material, prima facie material, then they will frame charge. That time you have had an opportunity of arguing. Then if it is a sessions case, you have to argue in the same way when it is being committed. Then thereafter what happens, when sometimes if you want to mark certain documents, or the prosecution want to certain documents and there is conflicts about admissibility of that document, then you can very well argue that. Same when you want to put some questions and the other side is objecting to that question, then you have to argue whether that question is admissible or not. These are the stages of argument. And finally, when you had an opportunity of consolidate argument. So it is very simple to argue the case. Sometimes what happens, the counsels to attract the colleagues as well as the court attraction and the client's attraction used to argue elaborately, but I don't think that is the proper form of argument. According to me, you first argue your case. It is a duty of the prosecution to argue the case. But normally the courts are now addicted to allow accused to argue the case and thereafter to the prosecutor to argue the case. I do not know how this procedure changes. Whatever it may be, it's all or it makes no much prejudice or a problem. My humble submission that you first state what all are the charges framed against you for the trial. That is first question. Then you have to argue after reading carefully about your questions put under 313 CRPC, because the courts are directed to put your questions about the incriminating evidence against you, upon which the court is going to convict you to answer for that. So the 313 questions should be carefully gone through, and if that questions are not sufficient for the facts stated in the charge, then your case is very good. case of acquittal. Suppose if that was not there, that means where the questions are sufficient to fulfill the ingredients set out in the charges, then you have to argue about the contradictions between the one witness and the other witness in 161 statement. That will be, and even if there are certain contradictions of statement available in the question put under 313, that will be most vital contradictions. Then the question was, whatever may be your case, unless and until you have shaken the credit of investigating officer by creating doubts whether what all are the failure on the part of investigating officer to know the truth or about the possibility of other accused committing the offense, or the final report was filed with exaggerated charges. These things you have to cross-examine. The IO's cross-examination, if that was elicited, and further these contradictions, omissions, improvement must be elicited through investigating officers. These all are the ways how to argue the trial cases in criminal cases. Whatever may be the summary trial or warrant cases instituted upon private complaint, or sessions cases by state or person's case initiated by private complaint. These will be the procedures. So for with example, if you want me to explain this, that I will take another day, because I must have a case on my table. So this is the way you have to argue. My humble submission is another aspect of arguing the case was, if suppose the lower court did not frame the charges for particular offence, but about to convict that offence, that is miscarriage of justice. If it is within the same category of the offence, if the court is going to convict you lesser gravity offence, though the charges were framed for more gravity of offence, that is admissible, but not this way, that framing charge for 393 and convicting you under 326 is not legally sustainable, and there is possibility of de novo trial. These aspects are there. Once at the final stage of argument, you realize that you have no case to get rid of the guilt of your accused being proved, then the alternative available to you was how to beef the facts with any other circumstance, any other evidence available, to see that the accused is convicted under lesser gravity offences. Suppose charges were framed under 326 and you are able to prove the court that there were sudden provocations, then the 326 will be reduced. Causing grievous hurt by dreadful weapon is 326. At the same, causing grievous hurt by dreadful weapons on sudden provocation, self-defense, all these things you will have another section for lesser sentence. All these things are there. You may further argue stating that though there was grievous hurt, the intention of the accused was not to cause grievous hurt. Unfortunately, the act which resulted to grievous are. That way, if you argue, then the court may realize your argument is apt to reduce the sentence. That is why we have to argue. Today, I hope that you understand this. If you're not catching my this communication, you hear the same once or twice, you will be able to understand it. I think my English is not that much of tough to understand. Best wishes.